typing is an essential after dictation. Try exam-oriented typing tests, check accuracy, number of errors, gain speed, and more. Complete the typing test in a given time. Read dictation materials. Subscribe to get contents via mail. Purchase shorthand journals and more.
By filing rejoinder to the supplementary counter affidavit filed by respondent number 1, petitioner submitted that though special police officers have been duly notified under memo number 8483 dated 4/8/1997, the notified officers have not been effectively implementing the provisions of the Act and discharging their statutory duties, and human trafficking seems to be on the rise. The concerned officers have perfunctorily addressed themselves to the issue on account of their failure to treat the victims rescued as per the provisions of the Act for non-availability of victim-friendly rehabilitation shelter homes with adequate support mechanism. In this connection, it was also pointed out that the state government has not taken any steps to provide adequate medical counseling support to the victim and the treatment meted out to them after their recovery is casual, in as much as they are left without any monitoring mechanism, and the entire rescue operation becomes an exercise in futility, defeating the provisions of the Act. In paragraph 3 of the rejoinder, petitioners referred to notification of the government bearing memo number 8443 dated 4/8/1997, whereunder special police officers were notified under section 13 of the Act, and submitted that bare perusal of the said notification would indicate that although the name of the Act has been substituted by Act number 44 of 1986, and the word suppression of immoral traffic in women and girls substituted from the nomenclature of the Act with the word prevention, but the authorities of the state are not aware about the change in the nomenclature of the Act, and thereby are also not aware about the purpose, large context which persuaded the Parliament to change the nomenclature of the Act to provide for prevention of trafficking and rehabilitation of the victims by ensuring minimum standard for correctional treatment, as also to make the penal provisions more stringent. In paragraph 6 of the rejoinder, petitioners asserted that the training imparted to the special police officers has not produced any tangible result, as they are not discharging their duties in terms of the provisions of the Act and continue to conduct raid without the presence of a woman social worker. Petitioners also filed rejoinder to the supplementary counter affidavit filed on behalf of respondent number 1, asserting in paragraph 5 that from the pleadings filed on behalf of the state respondents itself, it will appear that AHTUs were constituted in the year 2008 but became active only after the present public interest litigation was filed. Even now, nothing tangible has been done to prevent trafficking by conducting raid, rescue, and above all to rehabilitation of a trafficked victim. In the same paragraph, petitioners challenged the respondents to produce before the Honorable Court even a single case where a trafficked victim has been rescued, rehabilitated so as to free her from the clutches of trafficking or to prevent her from being further trafficked. In the same paragraph, petitioners further stated that they have often seen that after a victim is rescued, no sooner she is sent back to the same environment from where she was trafficked in the name of reintegration results in re-trafficking and negation of her fundamental rights.